Welcome to the ninth lecture of this lecture series introducing international arbitration practice. In the last lecture, we had discussed the topic of main components of arbitration clauses, where we discussed the WWHW theory. We said that if we answer the questions what, who, how, and where, we would be able to draft a basic arbitration clause. In this lecture, we will elaborate on the WWHW components further in order to draft the arbitration clause. Please recollect that the what component described the types of disputes that could be referred to arbitration. Parties usually provide for referring all disputes relating to an agreement to be referred to arbitration. Rarely, parties may agree to accept certain matters, that is, exclude certain matters from the scope of the arbitration clause. In this lecture, we will look at the what component first. Again, please recollect that we took note of both the Unsettled Arbitration rules and the SIAC arbitration rules that employed detailed phraseology to cover the range of disputes to be referred to arbitration. The Unsettled Arbitration rules said any dispute, controversy, or claim arising out of or relating to this contract or the breach, termination, or invalidity thereof shall be settled by arbitration. And the SIAC arbitration rules provided any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration. Thus, the range of issues covers all disputes, controversies, or claims under the unsettled arbitration rules. The SIAC rules calls all contractual issues as disputes. It does not matter whether you call them dispute or controversy or claim. All these are essentially disputes. Reference in this regard may be had to the decision of the Singapore Court of Appeal in Tiong Veri Sumito and others versus Antique Investments, a 2009 decision of the Singapore Court of Appeal, where the court held in para 23, if the arbitration agreement provides for arbitration of disputes or differences or controversies, then the subject matter of the proceedings would fall outside the terms of the arbitration agreement if A. There is no dispute, difference, or controversy, as the case may be, or B. Where the alleged dispute is unrelated to the contract which contains the arbitration agreement. The ordinary meaning of both dispute and conflict overlap here and must include any sort of disagreement. We should also add for the completeness that the phrase arising out of or in connection with that appears in the subject clause has a wide ambit that extends to all manner of issues that have a relationship with the SPA. A generous interpretation should be given to such a phrase. So here, sale and purchase agreement was in issue. So that is abbreviated as SPA. Now, likewise, the phrases used, such as arising out of or relating to this contract, or arising out of or in connection with this contract, express broad language covering all types of issues within the scope of the arbitration clause. That is what the second para quoted here says. Hair splitting distinctions while construing these phrases are not warranted. In Premium NAFTA Products Limited and others versus Philly Shipping Company, a 2007 decision of the House of Lords, Lord Hoffman stated in this regard, I do not propose to analyze these and other such cases any further because, in my opinion, the distinctions which they make reflect no credit upon English commercial law. It may be a great disappointment to the judges who explained so carefully the effects of the various linguistic nuances if they could learn that the draftsman of so widely used a standard form as Shelltime 4 obviously regarded the expression arising under this contract in clause 41b and arisen out of this charter in clause 41 C1A1 as mutually interchangeable. So I applaud the opinion expressed by Longmore LJ in the Court of Appeal at paragraph 17 that the time has come to draw a line under the authorities to date and make a fresh start. In my opinion, the construction of an arbitration clause should start from the assumption that the parties, as rational businessmen, are likely to have intended any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be construed in accordance with this presumption, unless the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. As Longmore LJ remarked at para 17, if any businessman did want to exclude disputes about the validity of a contract, it would be comparatively easy to say so. Therefore, using the term dispute and the phrase arising out of or in relation to would suffice. The remaining phrases in the UNCITRAL and the SIAC model clauses are used only as a matter of abundant caution, and not all jurisdictions may agree to enforce these clauses using a liberal approach. If you want to be careful, you could use the phrase any dispute, difference, or controversy arising out of or in relation to this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration. But if you prefer to have a crispier clause, you may use any dispute arising out of or in relation to this contract shall be referred to arbitration. The former clause has its own advantages because courts deciding to refer to arbitration, even issues such as fraud, rely on the wider language as one of the reasons for referring to. For instance, in Avital Post Studios versus HSBC PI Holdings Mauritius Limited, a decision of the Supreme Court of India dated 19/8/2020, the Supreme Court relied on the wider language used in a clause similar to the former one and held further any finding that the contract itself is either null and void or voidable as a result of fraud or misrepresentation does not entail the invalidity of the arbitration clause, which is extremely wide, reading as follows. Any dispute, controversy, or claim arising out of or in connection with this agreement, including any question regarding its existence, validity, interpretation, breach, or termination. So notice how widely that this arbitration clause covers, and that is why the Supreme Court noted that and stated that it was extremely wide. Now, coming to the who question, we had discussed that the who question referred to who should be the person arbitrating or administering the arbitration or appointing the arbitral tribunal. Although this may sound simplistic, there are three different types of persons or authorities contemplated. One, the arbitrators or the arbitral tribunal. Two, the appointing authorities. And three, the administrators or the arbitral institutions. All these three authorities are different, but most of the times arbitral institutions act as appointing authorities. Therefore, by merely choosing an arbitral institution, the issue relating to appointment of arbitrators would be taken care of through such designation. This is the reason why Article 10.2 of the SIAC arbitration rules provides if within 21 days after the date of commencement of the arbitration or within the period agreed otherwise by the parties or set by the registrar, the parties have not reached an agreement on the nomination of sole arbitrator, or if at any time either party so requests, the president shall appoint the sole arbitrator. This is important. The phrase, the president shall appoint the sole arbitrator. With respect to the three arbitrators, the SIAC rules provides in Article 11.3, unless the parties have agreed upon another procedure for appointing the third arbitrator, or if such agreed procedure does not result in a nomination within the period agreed by the parties or set by the registrar, the president shall appoint the third arbitrator, who shall be the presiding arbitrator. Now, the term president is defined in the SIAC rules to mean the president of the court includes any vice president or the registrar. Basically, the court here is the SIAC Court of Arbitration, which is nothing but the arbitral institution. Now, if parties want to refer a dispute to arbitration to be administered by an arbitral institution, it does not make sense generally to have a separate appointing authority. So, all administrative aspects relating to the arbitration would be managed by that institution. But if you go for ad hoc arbitration without involving any arbitral institution, it would make sense for the parties to agree upon an appointing authority. That's the reason why the Unsettled Arbitration Rules contemplates in Article 6.1 the appointment of such authority. It says, unless the parties have agreed on the choice of an appointing authority, a party may at any time propose the name or names of one or more institutions or persons, including the Secretary General of the Permanent Court of Arbitration at The Hague, one of whom would serve as appointing authority. In ad hoc arbitrations, it would make sense to have an appointing authority. So, what happens if you don't have one? You may refer to Article 11 of the Unsettled Model Law, which provides for appointment by the court at the seat of arbitration or the place of arbitration or other authority. Thus, the courts at the place of arbitration can be approached for constituting the tribunal in case the party appointed mechanism fails. This leads us to the where question. What if, in the above circumstance, you do not have a clause designating a seat? Which jurisdiction would you go to appoint the arbitrator? This problem is exemplified in the case of international arbitration. Take a typical scenario where there is a contract between the service provider and the service receiver. The service receiver is a USA based company. The service provider, say, is an India based company. And the service that is contemplated is a software for the UK subsidiary of the US service receiver. The service provider's team located in Singapore is working on the project, which will be delivered to the service receiver systems which are based in UK remotely from Singapore. And in case of disputes, the Indian party may invoke the jurisdiction of the Singaporean court for appointment of arbitrator in the absence of an express clause on the place of arbitration. But the American party may initiate proceedings in USA restraining arbitration on the ground of fraud in entering into the agreement containing the arbitration clause. This will lead to unnecessary jurisdictional tussle even at the stage of appointment of arbitrators. Therefore, it would be sensible to provide for the place or seat of arbitration in the arbitration agreement itself. This will save a lot of time and money for the parties. So, it is important that you select the seat. While selecting the seat or the place, it would be useful to follow the model clause of the Unsettled Arbitration Rules, which states in the corresponding part, the place of arbitration shall be dash, town and country. Make a mention of the city or town and the country. Although not frequent, there could be confusion regarding the town names. For instance, in an agreement between a party from Tamil Nadu, India and Massachusetts, USA, the agreement may provide for Salem as the place of arbitration. But both states, that is Tamil Nadu of India and Massachusetts of USA, have a city called Salem. In order to avoid confusion, it would be useful to say Salem, India. Or if the Salem of Massachusetts is what is chosen, then Salem, Massachusetts, USA. So that's all in this lecture. More in the next. Bye bye and stay safe.